Good morning and welcome to the University of Pennsylvania Law Review's Volume 170 Symposium. My name is Matthew Seelig. My pronouns are he, him, and I'm a white man with glasses, blonde hair, a blue suit, and a red tie. Again, welcome. We're sad we're not able to gather in person. We know that the remote format removes some barriers to access, but leaves many others in place and even creates new ones. So we are going to begin today with an access statement. We strive to be as inclusive as possible. To that end, here is some information about how this event will go. We have an ASL interpreter, Joy, and you are able to pin her if you wish to have her screen bigger. And we have manual closed captioning as standard accommodations for each panel and speaker during the symposium. We will orally identify ourselves when we are speaking. When we are speaking for the first time, we will describe our visual appearance. In all instances, we will state our name before we speak. And if a speaker shows a slide, they will describe and explain what is on the slide. We encourage participants to use plain language whenever possible and define acronyms or avoid using them altogether. We have a few channels by which to ask questions. Anybody may type a question in the Q&A tab. That's the Q&A tab and not the chat. We will have a moderator read questions unless the person asking the question prefers to ask orally. If that's the case, to ask a question orally, please indicate you would like to do so in the body of your question. Or alternatively, you may simply raise your electronic hand. We will then unmute you or allow yourself to unmute yourself to ask your question. Finally, we have a phone line where anyone can call in to ask a question. That number is 215-898-7060. You may also use this number to make any accommodation requests or report technology issues. You may also alert us to any issues via the chat. And again, just to clarify, the Q&A tab is for questions for our presenters, and anything related to accessibility or technology goes in the chat. And then we've posted this information in the chat for ease of reference. We do have continuing legal education credits available. However, we don't have any CLE related announcements or codes until our first panel. Now, I don't want to take any further time away from our substance, so I am going to turn it over right now to our editor-in-chief, Leticia Salazar. Leticia?
Thank you, Matt. As he said, my name is Leticia Salazar. I am the editor-in-chief of Volume 170 of the University of Pennsylvania Law Review. I am a Black woman with curly brown hair, wearing a blue shirt and a suit jacket. We are so excited to host this event both today and tomorrow, and we are looking forward to facilitating conversations around disability while also promoting disability scholarship. First, I want to start off with a few thank yous. To Professors Karen Tani and Jasmine Harris, our amazing faculty advisors for the symposium, to Dean Ruger, to Representative Presley, to Dimitri Islam and the Student Affairs Office, to Chris, Sam, and everyone in IT services at the law school, to Joy Harris and Donna Ellis, our ASL interpreters, to Ariana Jordan, our transcriber, to Matt Seelig, our wonderful symposium editor, whom without the symposium would not be possible, and last but not least, everyone joining us. We really appreciate all of the effort and excitement and conversation surrounding our symposium, and we can't wait to see all of your remarks and everything that we get to delve into as the days develop. Now I will hand it over to the Dean of the Law School, Dean Ted Ruger, who is going to welcome us with some opening remarks. Thank you.
Thank you, Leticia. My name is Ted Ruger. I'm the Dean of the Law School since 2015 and a professor here since 2004. My pronouns are he and his, and I'm a white male with wearing a blue suit with no tie, and have a beard that has a little more gray in it each year. And I'm really honored and grateful to be joining this symposium or helping to welcome it. It's, I think, a landmark event for this law school, for legal education in many generally, to have such a high level critical focus on disability and disability rights. And I'm so proud that that this institution is hosting it. Like most good things at this institution, it's driven by our student leadership, and so I appreciate the leadership from our law review students as well as faculty, a number of whom I'll mention in a few minutes, and faculty from around the country, and also our staff. Doing events in this COVID era is more difficult, and I appreciate the support that they've done. This is a profoundly important symposium. We will be looking in the next 2 days at disability's interaction with a range of other issues in American law and society, economic insecurity and precarity, reproductive justice, environmental harm, incarceration and the carceral state, and are bringing together scholars and student editors who are working on these issues, in drawing on different disciplines, asking new questions, revisiting old questions that have not been ever kind of properly answered, and dealing with problems that are and have long been significant, but only recently are receiving the kind of attention from scholars that I think they deserve. I think about my own teaching in constitutional law and civil rights. Many of us can name landmark cases as well as justices that are associated with leading opinions on rights discourse around race, around gender, around LGBTQ plus issues and landmark cases. I think, and it's an acknowledgement of us in the Legal Academy needing to do more and better. We have more trouble doing that with disability law. What are the leading Supreme Court cases? What justices or jurists and scholars are leading the discourse? Again, those of us who are committed to rights-based analysis and critical scholarship can do that, in our sleep for race and sex and discrimination and other areas of inclusivity. I think much less so, and I say this as somebody who is not as expert as many of our panelists, who of course could do that. I kind of speaking on behalf of the Constitutional Law and Civil Rights Academy. I want to acknowledge that we haven't given the attention to disability and the intersectionality of disability with other forms of inequity and discrimination that we have maybe more salient topics over the past, not more important topics, but more salient within the academy due to our own choices over the past few decades. And so this is an important corrective. I'm so glad that it's led by faculty, many of them newer faculty here who have either rejoined or joined us, faculty like Karen Tani, Jasmine Harris, Sean Osei-Owusu. I want to acknowledge the longtime contribution of our extended colleague, faculty colleague, David Furliger here, who has been kind of our leader and constant on disability law issues for decades, but also then recognize the infusion of talent and scholarly expertise that we have. To my knowledge, to this point about the Legal Academy as a whole, maybe understudying and under-focusing on disability issues. To my knowledge, this is the first time any top-ranked general law journal has ever devoted their annual symposium to a disability theme. So again, credit to our students for your vision, credit to the faculty who have helped our students frame this. This symposium will bring together different topics and disciplines. It's as I said, it's not just about disability, but about the intersections of disability with a number of other issues of inequity and exclusion. And as such, fits with an important vision we all have for this law school of, continuing to educate students from the broadest possible range of backgrounds, but focus, as we should, on the deep structural inequalities and unaddressed inequities that remain in our otherwise affluent society. This couldn't come at a more important time, and I hope it's the first of many such symposia here and elsewhere. And again, I want to kind of, with great gratitude, then turn it back to my student and faculty colleagues and leaders who really did so much to bring this conference together, and I'll be listening throughout the day and tomorrow with appreciation. So thank you.
Hi, everyone. My name is Karen Tani. I'm an Asian American woman with short black hair, wearing a black blouse and an eggplant colored blazer. I'm smiling very widely because I am thrilled to be here. So I will begin as well with some thank yous, and then I'll say a few words about the origins of this symposium before turning it over to my co-organizer on the faculty, Jasmine Harris. So on behalf of myself and Professor Harris, I want to offer thanks to people who have already spoken. We thank, first of all, Dean Ruger for his support of this symposium and for his willingness to grapple with issues of inequity and exclusion. Professor Harris and I both joined the faculty during his deanship. Today's event sprouts seeds of possibility that he planted and tended over the years. We thank Editor-in-Chief Leticia Salazar for her visionary leadership of the Law Review during a very challenging time. We thank Symposium Editor Matt Seelig for his tireless organizational work and his eagerness to work collaboratively with us on issues ranging from accessibility measures to the substance of particular panels. Managing Editor Erica Rodarte also provided invaluable organizational work at key moments. We are just in awe of these students' professionalism and dedication. The idea for this symposium took shape last year in conversation with various colleagues who write about disability and law. At the heart of that initial conversation was our shared recognition of a surge of interest in disability. That interest spanned different topics and fields, not only anti-discrimination law and social welfare law, but also criminal justice, environmental law, immigration, and more. The legal concept of disability also appeared to be engaging scholars who earlier in their careers had not made disability central to their work. And to be honest, I would count myself in this camp. I came to disability late via my longtime legal historian friend, Rabia Belt, who is on this program. And because through my historical work on social welfare provision, I came to see disability as the big story of the 20th century, of the late 20th century. But what I'm trying to describe is much bigger than my niche interests. With a frequency and urgency that feels different from the past, people in and out of academia seem to be thinking about issues in disability terms. Strategies regarding mask mandates and anti-mask mandates are a good example. You may recall that early in the pandemic, flyers were going around describing mask mandates as a violation of the ADA. The people behind these flyers were essentially recruiting disability civil rights law to do their libertarian work. This legal interpretation was quickly debunked, but it still went viral. Meanwhile, we also see disability-focused arguments on the other side of the issue. People on the program today have argued that disability law supports mask mandates and definitely counsels against statutes that restrict them. These examples illustrate what we call the disability frame. Building on the work of colleagues, we define the disability frame as the characterization of a particular controversy or problem as being about disability. This in turn implies that disability-focused laws ought to resolve or adjudicate the issue. In other words, the disability frame involves taking a particular issue and choosing to talk about it as a disability issue, rather than leaving the disability dimension unspoken or in the background. We recognize many motivations at play here. It is impossible to peg the frame to a single motivation. Sometimes, as in the anti-masking flyer, the disability frame is invoked as a shield to insulate someone from the reach of the state or exempt that person from an unwelcome responsibility like getting vaccinated. In other instances, the disability frame functions more like a positive right. It offers access to a particular benefit or resource, perhaps housing, educational services, or income support. In still other instances, the frame functions as the basis of a more systemic or policy level demand on the state for calls, for example, to restrict abortion, to ban the death penalty, or to impose public health measures. And most starkly, the disability frame has sometimes functioned as a reason to deny certain people basic rights and freedoms, such as sexual agency. What we see uniting these diverse examples is some degree of contingency. To those who use it, the disability frame might seem completely intuitive, like just common sense. But in the examples that we have in mind, that framing is not the only possibility. Consciously or not, the framer has made a calculation, a choice. The disability frame raises many questions. A preliminary question is why? What makes the concept of disability seem so available? We see at least 3 reasons. So first, although the general public has tended to adopt a narrow view of who counts as disabled, the legal definition of disability has long been more capacious and flexible. We see this in disability-based benefit programs, which are hardly generous, but have over time recognized more and more impairments as potentially disabling. We see it on the civil rights side, such as in the 2008 amendments to the ADA. These laws may not in practice protect as many people as they should, but there is no doubt that many people and experiences fall within their definitional ambit. Second, as Duran Dorfman will discuss tomorrow, the word disability is even more capacious than laws like the ADA suggest. In the English language, disability has signified various types of inability, disadvantage, and impediment. This linguistic openness has enabled people to stretch the concept of disability well beyond bodily impairment. Third, and this is admittedly speculative, but we think that no one is really policing the use of the disability frame. Maybe that is a good thing. Maybe it is a bad thing. We hope that this symposium will help us think through that. But simply as a descriptive matter, we have not found many examples of people being prevented from adopting the disability frame if that feels useful to them. Shifting from that preliminary question of why is the concept of disability so available, we have a set of questions that we hope can help us better understand this phenomenon and set us up to tackle bigger normative questions. First, some historical questions. How has the disability frame been deployed in the past? Can we associate any outcomes with that framing choice? Are there situations when this frame might have been deployed but was not? If so, why and with what consequence? We might also try looking at history through the disability frame. If we choose to apply the disability frame to the past, what do we see? What looks different? Our first panel takes up this set of questions. A second set of questions is about how we see the disability frame functioning right now. In what areas are we seeing it? Why these particular contexts? What is the goal? Saturday's first panel takes up these questions and will show the frame's intersections with criminal justice, environmental justice, and various forms of trait-based exclusion. We also have 2 panels that look at the disability frame from particular perspectives. Today's afternoon roundtable takes up a concept that seems to shadow disability and therefore hovers over the disability frame. That is the concept of cost, the perceived or actual cost of accommodating someone with a disability, the perceived or actual cost of supporting someone with a disability, the cost of being disabled, costs paid in time, money, health, and dignity. Another panel that comes at our theme from a particular perspective is tomorrow afternoon's practice-oriented panel. This panel recognizes that the view from practice is often quite different from the view from legal academia. We want to see the disability frame from all angles, and we look forward to what we will learn from this esteemed group. The final panel on our program tomorrow afternoon is forward-looking. By this point, we'll likely all have formed some ideas about the big normative questions. Do we want to encourage use of the disability frame? If so, when and how? Are there contexts in which we are troubled by the frame? Why? Is the frame itself limiting or constraining in some way? We hope this future-oriented panel will help us crystallize our thoughts and perhaps imagine alternative possibilities. I'm now going to introduce my friend, my collaborator, and my colleague, Professor Jasmine Harris. Thank you.
Good afternoon, everyone, and thank you, Professor Tani. My name is Jasmine Harris. I'm a Latina with medium-length brown hair, brown eyes. I'm wearing glasses with brown frames, mauve-colored lipstick, and a blue blazer and blue and white shirt. I want to echo my thanks to Matt, Leticia, and the entire Law Review staff for your work to make today's symposium a reality. Likewise, thank you, Dean Ruger, for your institutional support and your commitment to building a robust interdisciplinary anti-discrimination program here at Penn that includes and values disability. Professor Tani, thank you for bringing this idea to the table, for inviting me to join you, and for being an incredible colleague and collaborator. This day would not be possible without your vision, your patience, and your dedication. I would like to spend a few minutes now discussing the design of this symposium and mention a few goals for the next couple of days. First, with respect to the design of the program, Professor Tani just described the origin of this symposium and an overview of the disability frame itself and how it will unfold over the course of the next 2 days. The design of the program was just as important as its content to us. As disability scholars such as Bess Williamson and Amy Hamraie, Hamraie, have noted, design has played a critical role in disability discrimination. The design of physical and programmatic spaces reflects societal values, whose experiences matter and count. An ableist world is ableist precisely because it was designed without people with disabilities in mind. It presumes a particular body and mind will use and move in it. Professor Williamson's book, Accessible America, notes that the move towards greater industrial standardization and mass production gets reflected in the architecture just as much as it does the consumer products that come out of the factories themselves. Products that assume standing, walking, and male bodies as consumers of cars and homes. Efficiency becomes the hallmark of successful business practices. Efficiency, of course, gets defined as standardization, which in the end keeps costs uniform, predictable, and low. We will revisit this notion of cost later this afternoon. Furthermore, access and design are inherently political. From a legal perspective, they are the product of negotiations in Congress between members of Congress, private businesses, and lobbyists. What's reasonable, and thus what's legally mandated, versus what would pose an undue hardship on state, local governments, and private institutions, these are the trade-offs that took place. When we think of disability in design, we often think of architecture like curb cuts, ramps, elevators, markers of physical accessibility. They are visible, tangible, and subject to being photographed and frankly celebrated. To be clear, disability law has changed the built world in meaningful ways. Of course, this remains an important area for continued enforcement and compliance. However, less visible, less understood by the public, and as a result, more likely to be ignored or misunderstood, and for our purposes, more likely to be the subject of litigation, is the notion of disability design or access in programs and services. Nevertheless, thinking through program access is at the heart of Congress's intent to remedy historical segregation and social isolation through a comprehensive national mandate that advances inclusion and integration. So conscious of this political nature of access and design, we recognize an opportunity here to elevate its importance. We had a captive audience, our own institution, our own students, to discuss our collective values around inclusion. So we posed the question, what would it take to design and execute an accessible and inclusive program? This is not to say that we've done so successfully, and I'm sure many of you could tell us what is and will be missing, but the process of asking this question has produced meaningful dialogue and discovery, trial and error, and recognition of the work that remains. We adopted a universal design thinking plan in our planning process. That is, thinking through the different needs. Who should be at the table? Who should be at the table without having to go through administrative hurdles? By considering disability from the start, we were able to address access barriers preemptively and structurally so that certain accommodations were just part of the planning process, like our ASL interpreters, closed captioning, plain language, multiple options for asking questions and capturing your comments, built-in breaks of more than 5 minutes to allow for rest, accessibility statements, the use of verbal descriptions on PowerPoints along with alt text, verbal descriptors that people use to describe themselves and the surroundings. This, of course, does not eliminate the need for accommodations and frankly never will. People experience disability differently. And the whole point is that the built environment and the programs and services should not be presumed to be a one-size-fits-all or a one-size-fits-most. The innovation, and I say this in quotes, is that by considering disability from the outset, we've addressed a number of access barriers and have shifted the responsibility for planning and paying for, to the extent cost would be an issue, we move it from the individual to others. We've also created a precedent for this and future events at our institution, and we hope at other law schools. But inclusion also means different voices come together. We designed this event to be interdisciplinary, to reflect the study of disability in law and society. Law, sociology, history, art, literature, also across legal topics, administrative law, statutory interpretation, criminal law, tort, constitutional law. This reflects what Beatriz da Costa and Kavita Phillip describe as the work to be done in their co-edited book, Tactical Biopolitics, Art, Activism, and Technoscience. And I quote, "The difficult intersectional interdisciplinary work to be done includes, within one frame, the spaces of the political, economic, and the ontological, the battles of the activist and the epistemologist, the tracings of the historian and the artist," end quote. Second, this is intergenerational. We intentionally designed this so there are people with different stages of their careers, particularly highlighting more junior scholars, policymakers, and practitioners, but also including practitioners who've helped shape the ADA and other laws, and people who are part of what you'll hear from Rebecca Coakley and what she's called the ADA generation, those lives who've been shaped by the law itself. Turning to a few of our goals for the next 2 days, and then I will turn it over to Leticia. Our first goal here is active engagement. We didn't structure this event as a series of academic paper presentations as is typically done. There's ample time for audience questions and Q&A. Our second goal here is to recognize the limitations of this event. For example, the people here are not the only voices that matter, nor do we speak for everyone, and nor are these ideas entirely new. The scholars, policy practitioners, and lawmakers here, we build on the work of so many others. We encourage you to read the work of those who are not here. Some of the literature is available in the CLE reading list, but there are many more people thinking about disability across disciplines who are making incredible contributions to this field. So our third and perhaps most critical goal for the design of this symposium is epistemic. By epistemic, I mean the creation and dissemination of knowledge. Here, knowledge about disability, legal theory, law reform, and practice. A key reason for difficulty in changing social norms of disability that scholars such as myself have advanced is that there is a very limited set of images and narratives about disability in public circulation. So this has reduced disability to a set of more severe or of severe visible functional impairments, most often associated with mobility and sensory impairments, hence the quintessential wheelchair placard. This symposium creates new narratives, challenges faulty ones, not only through the content of the symposium, but by the expressive and demonstrative value of our design and the representation of people with disabilities who are here today as panelists as well. We're delighted to have you join us for these 2 days to engage in these important conversations. And with that, I'd like to turn it over to Leticia Salazar to introduce our keynote speaker, Congresswoman Ayanna Pressley.
Hey, everybody. I wanted to hop back in to reread our access statement. Simply aware that many folks have joined us since our beginning minutes where we read the access statement. We just want to, following up on what Professor Harris said, make sure that everyone is fully aware of the different aspects to the symposium that in our guidelines to make sure that everyone can participate, can ask questions, and can be a real part of this event. We strive to be as inclusive as possible. To that end, here is some information about how this event will go. We have an ASL interpreter, and if you wish to pin her to your screen to make her bigger, that is an option. As well as manual closed captioning. We will orally identify ourselves. Again, I'm Matthew Seelig. When we are speaking, when we're speaking for the first time, we will describe our visual appearance. In all instances, we will state our name before we speak. If a speaker shows a slide, they will describe and explain what is on the slide. We encourage participants to use plain language wherever possible, and define acronyms or avoid using them altogether. We have a few channels by which to ask questions. Anyone may ask a question in the Q&A tab, and that is the Q&A tab and not the chat. We intend to keep the chat for accessibility and technical issues. We'll have the moderator read questions unless the person asking the question prefers to ask orally. To ask your question orally, please indicate you would like to do so in the body of your question. Or alternatively, you may simply raise your electronic hand. We will then allow you to unmute yourself to ask the question. Finally, we will have a phone line where everyone can call in to ask a question. That number is 215-898-7060. You may use this number to make accommodations requests as well and report technology issues. And you may also alert us to issues via the chat. Again, one more time, just to make sure to make it clear that the Q&A tab is for questions to our presenters, and that the chat is for technology and accessibility issues. We've posted this information in the chat. And it's also available on our website. All right, I'm going to turn it back over to Professor Tani for additional remarks.
Hi, everyone. This is Karen Tani speaking. I wanted to jump back in because we have a few more minutes before our keynote speaker arrives. And for those people who just recently arrived, I wanted to highlight a set of questions that we hope we can think through collectively over the next few days. To repeat something that Professor Harris said, we really feel that we don't have all the answers. And although we have brought some people together around a compelling idea, we're still working through it. And we hope that we can do that again collectively. So here are some questions that I hope folks will keep in mind. First, what do you think of our working definition of the disability frame? I can read that definition again, if that would be helpful. So what I said earlier was that building on the work of other colleagues, we define the disability frame as the characterization of a particular controversy or problem as being about disability. This in turn implies that disability-focused laws ought to resolve or adjudicate that issue. So in other words, It's the taking of a particular issue and choosing to see disability, to frame it in disability terms. So the first question is, what do you think about that definition? How might we refine that definition? Second, what do you think about the disability frame? I think this is more of what we would call a normative question. Our symposium title, the subtitle, suggests the words opportunities, costs, and constraints as categories for thinking through that normative question, but that's just a start. Another way of framing this might be to say, do you find the disability frame compelling? Do you think it's useful, promising? Do you think it's troubling? Are there things about it that concern you? We'd also be interested to know, is there a particular basis of knowledge or experience that undergirds your views? We're really aware that people with different experiences and backgrounds might come to this question in really different ways. Third, we've tried to craft a program that explores the disability frame from various angles and perspectives, but surely we have missed some angles and perspectives. What have we missed? What work is left to do? Maybe it will turn out that there's the need for the disability frame too, maybe a follow-up conference. We would love to know, again, what we have missed. Echoing what Professor Harris said, we also want to make sure that folks are aware of other work in this area. We really don't want to be purporting to claim this idea as our own. And so if it would be helpful to you to have access to the larger body of scholarship that, that we're building this on, we would be really happy to share some ideas. Some of that material already is available to the folks who are doing this for continuing legal education purposes. There are some materials that are in a Dropbox folder for them, but we would be happy if folks want that. Please just be in touch with any of the organizers, and we would be happy to point you towards other resources. Again, we see this as a collective idea, and we hope that we're building a collective conversation. I will transition us now back to Editor-in-Chief Leticia Salazar, who will introduce our keynote speaker when the time comes. Thank you.
Apologize. I think we are still waiting for a few minutes for Representative Presley. We apologize, but I did want to take the time to, following up what Professor Tani said, share the Dropbox link. This has access to a number of the readings that Professor Tani has suggested. It also has access to speaker bios throughout the event, organized by panel, and then alphabetically, which I believe is also the order of speaking that we'll be taking. So if you want any further information on who is speaking, that is where we'll direct you. Additionally, we'll have our access statement, which we've said and put in the chat as well, and is on our website. And it has some preliminary draft abstracts from the articles we will be publishing. We again just really want to thank everyone for joining us. I think we've got a very exciting group lined up for even just today. We are going 2 days, but so excited for the 2 talks that we have scheduled today after our keynote speaker. Our first panel, is going to be focusing on the disability frame, looking into the past. And includes Professor Belt, Rebia Belt, Professor Nate Holdren, Leah Samples, and Professor Karen Tani, who we've all just heard in our introduction. And then followed by a half-hour break. At 3 o'clock, we'll go to our second panel, which will actually take a rather different approach from the other panels. It's structured as a roundtable. More of a conversation than a presentation of papers and discussion, but really just a discussion, and Professor Harris has already addressed this, but the discussion of cost within the disability context. And in that conversation will be Elizabeth Emons, Professor Emons from Columbia Law School, Professor Karen Gustafson from University of California, Irvine, and Professor Harris. So we are very excited for these talks as they're coming up. I think we still are waiting a few minutes, and we apologize sincerely for the representative, but we'll be back. We'll be here to kick things off in a moment or two. Thanks.